Hello, everyone. I'm Paula Clarkson from Rehab Robinson and Clarkson. Today, we're going to talk about estate planning essentials and what the differences between wills, powers of attorney, and trust are. I'm going to go ahead and share my screen so we can go through the slides. We picked this topic today because it's a question that we get pretty much on a regular basis. So just a little bit of background about our firm. We are an estate planning and business law firm. We do all types of estate planning, from basic plans to probate, administration of trust, foundational plans for young adults, as well as charitable planning, asset protection, and business planning, from formation of entities, helping the business owner, as well as helping them sell when it's time for them to retire. A little bit of background about me, but let's jump into everything. So we're going to go through 3 of the essential documents that are part of an estate plan that are often confused on what you're allowed to use them for. So we have wills, powers of attorney, and trust. So let's start with a will. What is a will? A will is a legal document that expresses where you want your assets to go after death. So it is only effective when someone dies. So if a person is alive, they're incapacitated, then the will does not do anything. And it just allows your assets to be distributed. You still do have to go through the probate court, guides the distribution process, but your will directs who the named executor is that you appoint in your will, and will head up your probate estate. And you can also name guardians in your will as well. Guardians to take care of your children through their person or their estate, meaning who they get to live with. So the will covers assets that you own alone in your name when you die. So basically, anything that does not have a beneficiary designation or doesn't transfer automatically. So, for example, if you are a single person and you have a bank account only in your name, when you pass away, we need to calculate and see if that is above our probate threshold. In California, the probate threshold is $208,500. So if I died and I only had an account in my name that was, say, $30,000, I have not hit that threshold. I can pass away and my estate does not go through probate. Regardless of whether I have a will or not, then if the asset exceeds that 208,000, then it will go through probate. And then we follow the terms of the probate of the will to show who are my beneficiaries, who is my executor. So it is the guidepost. And once you file that, whether you have a will or not, and you're going in the probate court, it all becomes probate public record, and anybody can see it. Obviously, anybody that is an heir or a beneficiary named in your will get a copy of the will when the notice of the probate is started, and they have a period in which they can contest the terms of the will, whether they believe that it was done through duress or you didn't have capacity when you were creating it, or things like that. There is a time period before the administrator or executor is appointed. So we always get asked, when do we use a will? I would say that everyone should have a will at age 18, because if you don't, as we'll discuss, California has an estate plan for you. So even if you have less than the $208,000, your assets don't automatically go to the people that we would normally think they go to. So having a will at least defines who they go to. And especially if you have minor children that might be beneficiaries, within your will, you can provide how they get those assets over their lifetime. Maybe you want to have it held for them. That's called a testamentary trust that can be created through your will, or you give the assets to them outright. But there can be problems if there are minors. So, and there are sometimes people that specifically want the estate to go through probate. So they will list all of their beneficiaries in their will. So that allows the court supervision and gives everybody the opportunity to speak up if they have any problems with it. Generally, most people do not want that. They don't want the public record. They don't want the timeline of probate in California, but in some instances, it might be a good thing. And as I mentioned before, we always want to be able to name guardians, the people that are going to raise your children, so that the court isn't going blind when they may need to name minors or guardians for your minor children. So the downside of having the will and going through probate is that it usually takes 9 to 18 months, sometimes longer. Especially in Orange County, the courts are backed up. So we, file the probate, and that's asking the court to recognize the will. Usually those hearings are set out a couple months. Once the will is recognized and the executor is appointed, there's time period for creditor notice. We have to file inventories with the court, pay all the final bills and things like that. No distributions on anything that is going through probate until the probate is completed. So that means that if you had beneficiaries that you wanted them to have access to your assets, probably using just a will is not the best option because they have to wait until the probate is completed. So also, when you just have a will, you have court cost, privacy is an issue, and you may be able to protect, limit the ability for your beneficiaries to be protected from creditors and poor decisions, different than in a trust. But basically, a will, like a trust, does dispose of your assets, but it does require the court process. And the person that is in charge of the will is called the executor. So, and that makes a big difference because we often have people saying, oh, I'm the executor of my mom's trust. No. And the executor is only once the court appoints them. You nominate them in your will, but they are not officially the executor until the court appoints them and the probate is opened. So I mentioned, just using a will and going through probate can be a little bit more expensive. In California, the fees for a probate are statutory. So meaning that the attorney and the executor get paid a specific dollar amount based on the gross value of the estate. And this is the chart showing what is the fee schedule. So basically, when you're looking at $1 million estate, then you are at about $23,000 for the attorney, $23,000 for the executor, and then there's usually about $2,000 to $3,000 of court cost involved. So let's give you an example. Say that Joe dies, he owns real property, his house worth about $900,000. He has some bank accounts, checking, savings, brokerage type investment accounts totaling about $400,000. And then he has an IRA that's about $250,000. So the first thing that we look at is what assets may be able to pass automatically because they have a beneficiary on them. So with his assets, the first thing I would look at is the IRA. Did he name a beneficiary? If he did, then it is not part of the probate, and your will doesn't govern it. The beneficiary designation governs it. And then the second part I would look at is Joe married, and are any of these assets held in joint tenancy? So if he has his checking account joint with a spouse, or his home is held as joint tenancy or community property with right of survivorship with his spouse, those assets will pass automatically because of operation of law, and his will really doesn't matter. But the will would be very important if Joe's wife or spouse had passed away first, because if Joe's spouse passed away, then now he is the sole owner of these assets, and he has the house just in his name alone. He has the bank accounts in his name alone. Maybe he forgot to name a secondary beneficiary on his IRA after his spouse. Then all those assets would go through probate, and his will would be very important because we would follow the terms of the will to say who his beneficiaries are. So if we go through probate on these assets, if we look at the house and the financial accounts at 1.3 million, the total probate costs are $52,000 in statutory fees split between the attorneys and the executor, and then about $3,000 in cost. If we have to include the IRA in that total, because he didn't do something very simple of naming a beneficiary, then we're looking at $57,000 in fees that is split between the attorney and the executor. So by having the will, Joe will be able to direct where the assets go. If he doesn't, then we follow the California plan. So what is that plan? Under California law, if a person passes away, then we look to first their spouse. But then if they have children, their spouse and their children split the assets. And it really depends on how many children they have. If it's one spouse, one child, 50-50. If it's a spouse and multiple children, then the spouse could get a third, the children get 2/3. So it's very important to create the will at the minimum to be able to say where your assets go, because you may be unintentionally disinheriting your spouse or potentially another party if you did not want your assets to all go between different people. I would generally think that most people want their assets all to go to their spouse, but they could end up leaving a lot to their children a little bit too soon. If a person doesn't have a spouse or children, then we look to their parent, their grandchildren, their parents, siblings, things like that. We actually just recently had a probate where the person passed away, had not been married, did not have children. Her parents were passed away. Her sole brother had passed away, and he didn't have any children. So we had to go then up to the parents' siblings and nieces and nephews and things like that. And we were out to about 50 people, and they were second and third cousins. And it was quite an interesting thing. All these people that probably never even met the decedent. But had she created a will, she could have left those assets to maybe friends or charities of choice and things like that. Instead, a lot of family members that don't even know her ended up benefiting from her passing. So the next document we have that's very important is the power of attorney. So a power of attorney is a separate legal document that allows someone to make financial decisions for you while you are alive. Basically, the person is stepping into your shoes. So for example, if you have the will, that only comes into effect after you've passed away and disposing of your assets. The power of attorney is only effective while you are alive and stops working when you have passed away. Okay, so we can't use it anymore. It doesn't matter what happens. As soon as the person passes away, the power of attorney is no longer effective. So we have different types of powers of attorney in California. Durable power of attorney means that basically if I create it while I have capacity, once I become incapacitated, it is still valid and keeps going. That's generally the way that we like to create them, because the whole purpose of it is that if you cannot manage your own affairs, you're naming someone to do it. We also have a springing power. So even if it's durable, it can be springing, meaning it only becomes effective upon incapacity, or you could have it effective immediately. So a lot of times between spouses, we'll make the powers of attorney effective immediately. One spouse is out of town, the other person can handle financial affairs without having to prove the incapacity. But there are some times where it may be a single person or someone that doesn't, maybe they have a corporate or a third party professional trustee or power of attorney, their agent. They don't want that person to be able to get into all of their things right away, but they want them to be able to take over when they become incapacitated. So in those cases, we would say, yes, it's durable, it continues upon my incapacity, but this agent can only serve as my agent if I am deemed to be incapacitated. And usually we put in the power of attorney that is upon 2 doctors confirming that you do not have capacity. And then limited, you could always give someone a financial power of attorney that is limited to just specific things, specific time periods. You have the limited power of attorney to sell my house when I'm out of the country. You have a limited power of attorney to deal with my financial affairs when I'm going in the hospital for surgery. We can limit it to task. We can limit it to time frame. So you would use the power of attorney for incapacity purposes most of the time. For, like I mentioned, travel, illness, business management needs. We have lots of clients that are, traveling all over the country or over the world and sometimes cannot do things. We believe this is an essential document for anyone that is 18 years or older. So, once your child, my daughter turned 18 last year, I had her sign a power of attorney, because if she is somehow incapacitated, cannot manage her financial affairs, I don't want to have to go to the court to get permission to do that. The power of attorney gives me that permission when she's incapacitated to be able to get her last paycheck, to apply for Social Security, to pull money out of her retirement plan, those types of things, to help her pay her bills, taxes, cancel her gym membership, those types of financial effects that you might need to do for someone if they are incapacitated. So it's very important, like everything, there are limitations on the power of attorney. So generally, if you have the assets exceeding the 208,000, we recommend a trust, which we're going to talk about next. But a power of attorney governs assets outside the trust, while the trustee governs the assets in the trust. So generally, the things that are outside the trust are going to be retirement plans, government benefits, life insurance, collecting mail, like I mentioned, canceling your gym membership, canceling your Netflix membership, those types of things. Your agent under your power of attorney, although they're stepping in your shoes, generally cannot make changes to your trust unless it's very specific and allows them to. And generally, your agent can be a different person than your trustee. We generally like them to be the same person so that they can manage your financial affairs regardless of where the assets are. And along that line, we generally like to name whoever your executor of your will is, the same as your agent under your power of attorney, the same as your trustee that we're going to talk to, so that you have the same person managing your financial affairs, whether you're alive and incapacitated or once you've passed away, because maybe they've already had control of things and allows that continuity to continue. So let's give an example on here. Joe is a living trust holding $900,000 for his home, and he has investment accounts. And he gives his daughter, Sarah, financial power of attorney. So if he becomes incapacitated, Sarah can't deal with anything that's in the trust. The trustee deals with that. But she can take care of things that are outside the trust. File his income taxes, collect his Social Security, determine who can be the beneficiaries or how much is pulled out of his 401k or IRAs. So basically, if you have a trust, the power of attorney, your agent and your trustee work together. If you do not have enough assets that go to the need of having a trust, then your agent or your power of attorney will deal with all of your property. If you are incapacitated and you don't have a trust, but you own a home, your agent could potentially sell your home. If you needed to go to assisted living, they could rent it out. They could help, get a reverse mortgage on it, things like that. So we have to not only look at what are the documents, what powers do they have, then we look at where are the assets. So like I said, if you have a home, and usually you're going to have a trust. So then your agent under the power of attorney will not control that. But what if you discover that your parent needs to go to assisted living, they are now incapacitated, and you realize, oh no, mom never put her house in her trust. Oftentimes, the agent under the power of attorney has the power to fund the trust. All of our documents are created that way. So that's always a good thing. And we recommend that our clients, if you know that your loved one is going to be passing away soon, if their health is deteriorating and you're taking over as their agent under the power of attorney or as successor trustee, it's always a good time to look and double check how title is on everything. Because as the agent, you can put things in the trust. As the agent, often you can update and make sure that there are beneficiaries on the retirement plans, on the life insurance. you wouldn't believe how many times we have clients that will have, like, the husband will name the wife as the beneficiary in his retirement plan or his life insurance, but he doesn't name a backup. And if his wife dies before him, there can be problems in those assets because they don't pass automatically, are going to go follow his will if he has one and go through probate. But as the agent under the power of attorney, the agent can be proactive and go through and potentially either move those assets into the trust, name the trust as a beneficiary, or name other people as a beneficiary in accordance with the incapacitated person's overall estate plan. So let's talk about trust. So when you have a trust, it's a separate legal entity that holds your assets. So there's a lot of different titles with regard to a trust. We have the grantor or settlor. That's the person who creates the trust. The trustee is the manager of the trust, and that person can change. It usually is the person who creates it. If I create a revocable living trust for myself, I'm usually going to appoint myself as the trustee. But then I can have successor trustees if I am incapacitated. I could potentially have a co-trustee to help me manage things. Oftentimes when you have spouses, they are both the co-trustees of their trust. And then we also have beneficiaries of the trust. So a lot of different terms: executor of a will, agent under your power of attorney, and then the trustee of your trust manages the assets. So you can never be an executor of a trust or a trustee over a will, things like that, or power of attorney over the trust. We hear that a lot of times. So different documents, different roles, very similar and intertwining roles, but definitely different roles. So when you have a revocable trust, during your lifetime, it can be changed, modified as much as you want. As I mentioned, you're usually your own trustee. And then if you become incapacitated, you have your successor trustee. Usually upon your death, the trust becomes irrevocable and your successor trustee takes over, the person that you have named. Oftentimes people will create irrevocable trust during their lifetime. This is usually for them to be making gifts. So you could be a trustee of a revocable trust. You could be trustee of an irrevocable trust. Generally, those irrevocable ones, again, are for tax benefits, but I am giving up control. If I set up a trust for my daughter and I'm giving her assets, the IRS, if I'm making a completed gift, I am not allowed to be the trustee of that. So I have to give up control, name somebody else as the trustee over that to manage those assets. So as I mentioned, you're going to use trust when you want to avoid probate, maintain privacy because we don't have to file anything with a court, provides the ongoing management after death. Oftentimes wills will just say the assets go to beneficiaries outright. You can, as I mentioned earlier, create testamentary trust, meaning your will creates a trust to hold assets for a period of time. It's not as common, but it is possible. But generally, the easier way is to have the assets in the trust. Your trust provides where the assets go. For example, if you had a minor child, if you had a will and it left the assets to your child and they're a minor, now the guardian for the minor will have to open up a guardian of the estate to manage those assets with the court until that child is 18. Versus if you had those assets in a trust and I say, my successor trustee can manage these assets for my minor child, and my minor child does not get control of them until they're, say, 25, 22, whatever the age is I think is appropriate. Court does not have to be involved. My child gets the control when I say they get control, and the trusted person that I've named, my trustee, will be able to manage it. And generally, we say these are for larger estates. California, the limit is $208,500. It's also a great way to leave assets to people with disabilities, because then there's ways that they can still be able to qualify for some of their needs-based government benefits and without depleting all of the assets that are left to them first. So just again, the difference between what a will is and what a trust is. A will goes through probate at death. The court validates the will. The executor is appointed. and there's public supervision and reporting of all the assets. California, it's usually a 9 to 18-month timeline. If you have a trust, it's private. There's no court involvement. The trustee just follows the terms of the trust and is able to administer it. Your successor trustee can step in immediately, which means it's private, the court's not involved, and they can even start making preliminary distributions. We often have cases where that happens, whereas I mentioned when you have a will and your assets are going through probate, you cannot make any distributions to the beneficiaries, whether they're the spouse, the children, whatever, until probate is done. But if you have a trust, then we talk to the trustee, determine what the assets are. The trustee does need to marshal assets, make sure all the bills are paid. But if we can make a good faith estimate that there's more than enough assets to cover the debts, then we might be able to start making preliminary distributions, because oftentimes there is a need sooner rather than later. So here's another example. If Maria dies with a $2 million estate, her will-based plan will require probate in California. And it'll take about 15 months. And then we also have about $70,000 in fees. It can be very, very expensive. Where if her neighbor Carlos died and has those same $2 million of assets in a living trust, his successor trustee can manage taking over those assets right away with minimal cost, privacy, and so forth. And it, most of the time, is not going to cost even close to $70,000 to administer that trust, unless there's some discord amongst the family. So when you have a trust, though, we always have a will, okay, as a backup. And generally, when you have a trust-based plan, the will is going to say that the beneficiary is your trust. And we call that a pour over will. So that, because there are sometimes assets that people forget, maybe after they create their trust, and if they end up totally more than that 208,000, those few assets may go through probate that don't pass automatically, but then they get pulled into the trust at the end and distributed in accordance with the rest of the plan. So some time limitations we have. When you have a will, you're supposed to file it with the court and probate it, start the probate process within about 30 days after death, where there's a formal creditor notice. When you have that, and like I said, the 9 to 18 month time frame, as well as the court taking jurisdiction and final determination, where if you have a trust, we do have to lodge the will within 60 or 90 days with the court, but it's not a formal probate. We just send it to the court, they scan it, keep it in the back, do whatever they want, but then we don't really need it anymore. There is a creditor period that can be given, but it is not required in a trust. So having the trust-based plan with a trustee is often better if you don't want to make things public to your creditors. There's a 1-year statute of limitations. So if we don't give creditors notice of the passing and the 1-year tolls, they can't make any claims. But with a probate, we're required to give them notice. And oftentimes, though, we are able to make distributions within 6 to 12 months. Oftentimes, it just depends on the assets and the makeup. If there's a house that needs to be sold or something like that, that may delay things. But generally, the administration with the trust can be taken care of much quicker. So when we look at a complete plan for people, for the financial side of things, we recommend all three. If your assets are over 208,000, we want you to have a trust. We want you to name a trustee to manage the assets upon your incapacity, upon your death. Along with that, you're going to have the power of attorney to govern the things that are not allowed to go in the trust. Retirement plans, 401ks, IRAs, collecting your Social Security or other government or employment benefits, just by law, are not allowed to be part of the trust. We do want those things, if they are allowed, such as an IRA, a 401k, to name beneficiaries so that upon your passing, those then pass automatically to the right people, versus not having a beneficiary and having to then go to your will and make a distribution. When you have a trust, as we mentioned, the will pours over. But if you do not have assets that exceed that amount, or you choose not to get a trust, then we recommend at least having a will so that you are choosing where your assets are going and not the state of California. So again, living trusts are generally going to hold real estate, investments, business interests, your personal property. The pour over will is a catch-all. The power of attorney handles things when you're incapacitated for things that are outside the trust. The power of attorney and the trust go hand in hand while you're alive. The power of attorney stops when you die, and then the trust will, or the will could come up if you don't have things properly put in the trust. Often mistakes that we see are people having one agent, one trustee, one executor named, and not multiple. Like, we usually like to have at least 2 people named, because if the first person that you named predeceases you or is incapacitated or even just doesn't want to do it, it's nice to have a backup person. Otherwise, there can be different problems about who gets to be appointed. And, part of doing an estate plan is making sure that your wishes are taken care of. We see a lot of times people, especially when they do their estate plans on LegalZoom, they create their trust and they think they've done everything right, but they didn't fund their trust. If you don't put your assets that are allowed to be held in the trust, you're gonna have a probate. So hopefully then you actually have a will that is a pour over will. We've seen people that they name certain beneficiaries on their trust, different beneficiaries on their will. And if the assets are in their name alone when they die, they're going to pass according with the will. So we like to have a cohesive estate plan and go through that with you, because they can be very confusing. We often have clients that assume that the power of attorney can handle everything during their incapacity. Not always correct, because we always, we're trying to do some planning and avoid probate and things like that. So sometimes you just have to look at the terms of the power of attorney. Ours are pretty broad, but sometimes we'll see them and they're very limited, that they don't allow someone to make a trust for, if you have a loved one that's become incapacitated, you realize, oh no, their estate's going to be subject to probate. Then we have to look to the power of attorney and say, well, as the agent under the power of attorney, do I have the power to create a trust for them? Sometimes yes, sometimes no. So it's better to kind of look at the whole picture and coordinating all the beneficiary designations, or even sometimes we have people that don't name beneficiaries. We're going through a probate on an IRA right now because the decedent named his spouse as the sole beneficiary, but sadly his wife passed away before him. So there is no named beneficiary, and we have to probate that retirement plan. And then also the last thing is naming minors. As we talked about, when you have a minor, if they're under 18, they're not going to be able to collect assets. The guardian that you've named for them would then have to open up a guardian of the estate for them, if assuming you've even named one. And then that person, the guardian of the estate, would be in charge of that person's money and having to account to the court and everything. And the minor gets that money then when they're 18. And that sometimes can be troublesome when you have a child that, in this situation, they've lost at least one of their parents. And then when they're 18, being able to get a hold of significant assets could be a recipe for disaster. So we believe at the minimum, everybody needs a will and a power of attorney. If your assets exceed the probate threshold, then we recommend you get a trust as well. Also, you have to we've had clients where their estate is under the $208,000 threshold, but because of their family situation, we recommend having a trust. For example, a divorced parent that has a minor child, because they didn't want the other spouse managing the assets. So the assets got left in a trust, even though they were under 208,000, but we were still able to protect them, have those assets readily available for that child, with the trustee, the person, our client, named to manage those assets for their child. And it's always then important to review the assets, your documents periodically. Sometimes, like I said, the people you've named now have passed away. Maybe they've moved away. Maybe they're no longer in your life for any reason. then making sure that you have, a couple people named as your backups, so that it is important to have the right people in place so that your plan does what it does. So we have a couple of questions. The first one is, if you have a trust, a will, and a power of attorney, do you have to make the same person people the executor, trustee, agent, or can they be different people? You can name different people. That's not an issue at all. Generally, we do recommend naming the same people because they're going to, like, while you're alive, if you have Alzheimer's or otherwise become incapacitated, you'll have someone managing your assets, whether it's outside the trust using your power of attorney or in the trust. And they're managing it. And then when you become incapacitated, oftentimes it's a little clunky if you have to then turn it over to a different person. And not only time consuming to get the accounts moved over to a different person, but maybe continuity of how things are managed and distributions are done. So I generally do recommend naming the same person, but there could be instances where people decide they name different people. The next question is, how often should I update my estate plan to ensure that any newly acquired assets are covered and don't fall into probate? We offer complimentary reviews for our clients every 3 years to review their plan. But honestly, I would take a look at it every year, maybe at the time you're doing your taxes, just to double check, because it's very easy to double check your bank accounts or your investment accounts, because you're going to get your statements. If those assets are held in your trust, the statement address is going to indicate that, or even once a year, just through work or where your retirement plans are. Ask for a copy of the beneficiary designations just to double check. We always forget, but make sure that those are the right people. So many times people have come into the office and they're like, "Oh, I named that person." They're like, "Oh, I haven't talked to them in 10 years." So it's really important to look at the people and to look at your assets. Ideally, when you're acquiring a new asset, opening a new bank account, transferring financial institutions, buying a new house, that generally is the time to think, okay, I have an asset. Do I put this in the trust? Do I name a beneficiary? That's ideally the time. We probably at least once a week, oftentimes more, we are getting calls or emails from clients saying, I'm buying a new house, I'm doing this new account. I know I'm supposed to do something. What do I do? So do not hesitate to reach out to us. We're more than happy to help you with that. And it's always easier, for example, when you're buying a new house, to take title during the escrow process in the name of your trust versus having to do it after the fact. The next question is, do you recommend that your power of attorney and trustee be in the same state, or is it fine that they live elsewhere? It doesn't matter. It's just, can the person do the job that they're going to need to do? We have lots of clients that their named trustees, powers of attorney, do not live in California with them. So, in this day and age, a lot can be done online. A lot of the banks are national, if not international. There are problems when the trustees and your agents are out of the country, but as long as they're in the United States, it's generally not a problem. We've had executors that are out of state. They, sometimes they'll fly in to handle some things if there are just local California branches of their financial institutions, and they'll get them moved over. But oftentimes it's very easy to manage when they're living outside of the state. And then the last question we have right now is, what types of assets are not usually covered by a will? And are there any assets not covered by a trust? Okay, a will cover any asset. So anything that a person dies owning in their name alone that does not pass automatically, and I say passing automatically, like a beneficiary in a life insurance policy, a beneficiary in a retirement plan, a house held in joint tenancy with somebody else, those pass automatically. If I die and I only have assets in my name alone, no matter what the asset is, it would go through probate if it doesn't transfer another way. The trust is the transfer mechanism. So basically, the main assets that cannot be held by the trust are retirement plans. So it's going to be 401ks, IRAs are just legally not allowed to be owned by the trust. You would generally name a beneficiary on those. The trust can be a beneficiary, but there are tax consequences with that. So it's best to talk to your advisor before making that decision. Your life insurance can be held in the trust. Your real estate, business interest, all your financial assets, those types of things, personal property, digital assets, trademarks, all of those types of things should be in the trust. But then going back to the power of attorney, if I'm entitled to Social Security, my Social Security should be deposited into a bank account held in the trust. But if there were problems with the Social Security Administration skipping a payment or doing something like that, my trustee does not have the power to call them. My agent under the power of attorney can call them. Generally, the trustee doesn't have control over the credit cards, control over canceling your Netflix, canceling your gym membership, going to the post office and collecting your mail. That's why you have the power of attorney. So they go hand in hand working together. But generally, it's government benefits, employee benefits that we're looking at that are not going to be in the trust. But then we have to look at those things should either, like Social Security, end with you, or having a beneficiary on those, whether it be the trust or individuals directly, so that we do not have to use the will and go through probate. So that's all the questions we have today. If anybody has any additional questions, feel free to reach out to me or any member of our team. We are going to have another webinar on November 19th called Debunking the Common Estate Planning Myths. So we're going to go through some of the ideas that we hear a lot from clients where they think one thing when in reality or legally it's not. So if you have any specific myths or questions that you have, feel free to send that to us ahead of time, and we'd be happy to address those before or during the webinar. So thank you very much. We hope you have a wonderful day. We will also send out copies of this webinar shortly if you want to take a look at it or forward it on to anybody else. Thank you.